Hi guys, how are you doing? For those who are joining us live, and of course those who will be joining us later on, thank you for coming through. A huge thanks to 4C Integrated Communications for having me to discuss intellectual property issues and branding, especially in the marketing and advertising space. I think for the purposes of putting this discussion into context, I'll just look into the basic definition of intellectual property, but of course I think we are going to focus more on the trademark and copyright issues around the marketing and branding space. So basically intellectual property refers to the creations of the mind, and in this context we mean things like inventions which are protected through patents. We've got trademarks for protecting brand names and logos. We've got copyright, trade secrets, industrial designs, and geographical indications. And for the purposes of this discussion, I'm going to focus more on copyright and trademark protection. And of course, these are some of the intellectual property aspects that really more closer to our audience. I understand there are people in the marketing space, in the advertising space, and of course different professionals as well within that space. Now, there are certain types of intellectual property assets that are, really encountered in this creative and marketing space. We've got trademarks, we've got domain names, company names, etc., you name it. We've got copyright. And in terms of copyright, there are other aspects again that we then need to look into, like art, photographic libraries, graphic designs, video, audiovisual materials, promos, and stuff like that. And for other branding and marketing agencies, you also find that you guys do advertising effectiveness research, you do market research, so things like market research results and all other research files are also some forms of intellectual property. But the biggest question normally is who owns what? In this context, we've got the branding agents as the employer, we've got the employees, and we do have the client. So who owns what? I'll give you an example here where we can sort of subdivide intellectual property rights in terms of interests and of course uses. Now, a very good example is an advertising agency. Some of them, they've got internal employees, and of course in some cases they use the services of freelancers, especially writers, to create content for use in different advertising platforms, including print. Now, when that happens, payment for work doesn't really automatically give ownership, especially to the client. This has to be understood both from the client's point of view and from the branding or marketing agent's point of view, where just payment for what might be referred to as commissioned work would be considered as payment for the intellectual property rights. So in this case, what we normally recommend as experts is to have a specific contract between the agency and the freelancer, which means that the freelancer is assigning the intellectual property rights to the agents in exchange of that payment. In this case, the word assignment is very important because the freelancer is actually surrendering the rights into what they've created to the agents. That's very important. And then from an agent to the client point of view, you might find that in some cases the client would want to use the work that you would have created for them, be it a promo for the digital space, or be it for TV and stuff like that. And then all the marketing collateral or the content that has been created, they might want to use it for other specific purposes outside the agreed and paid for use. So in this case, we also need to make sure that intellectual property rights are transferred and the contract specifies use as to form like form specific kind of agreement. We've had situations and experiences where sometimes agencies, they end up complaining that no, we did work for this client and created these videos, created these images for this specific campaign, but however they've proceeded to then continue using this content for other campaigns which are also commercial, and we haven't been paid for that. And again, those are the issues that they need to be addressed from a contractual point of view. In terms of ownership, still on that same point, I'll also talk from the context of the UAE jurisdiction, and of course the Indian jurisdiction. I understand we also have some audience from India, so feel free to throw in your comments and questions so that some of them we can then address them as we proceed with the broadcast. Now, the issue of ownership, there is the employer, there is the employee, then there is the client. So the employer, as a marketing or a branding agent, has to be very careful in terms of addressing the issue of ownership. Of course, the law generally says that the intellectual property that is created during the course of the employment is owned by the employer, which in this case means that this should also be addressed from an employment contracts point of view, and the employee should be aware of that. Now, if the ownership is transferred to the employer, a separate agreement with the client also looks into addressing that, way the employer is generally the owner of the intellectual property, but when the client pays, the intellectual property rights going to be assigned to the client. Mind you, copyright, the right to reproduce, remains in the hands of the one who has created the work, which in this case is the branding or marketing agents. They've got the copyright. Now, when we look at it from that point of view, we then need to make the client understand that part of the agreement is also to transfer the rights in that content, and the client can use that content the way they want if the contract permits. I'll just give you some examples of certain ownership issues that normally rise. And of course, when we outsource, we use contractors to do some work or to create some work for us. A very good example is when a company engages a software engineer or a software company to write a computer program for them. This is an internal computer program that you intend to use as a branding agent or as a branding professional. If you do not have a contract that specifies and speaks to the transfer of intellectual property rights, what that means is that the creator, that company, or the software company or the software engineer that you have engaged, they still have the rights in terms of that software that they've created. And for UAE, we do not have software patents, so that's copyright. And that right to copy or to reproduce still vests in the creator of that software. And as such, you then need to make sure that there's a contract that specifies that as they create the software for you, they're also transferring the rights to you in terms of intellectual property, and of course the source code. Another example is when companies engage industrial designers, of course, to design new designs or electronic banners. We've got electronic banners in the advertising space. You engage someone to create that, and when they do that, they still own their intellectual property rights, and a contract should always specify that they've created that design and they're going to transfer the rights to you. A third example is when a company engages a marketing consultant, which in this case might be an individual or might be a company, to design a logo, right? And this has been happening for so many times. And when they do that, they also need to make sure that the contract addresses the transfer of ownership of copyright in that logo to the client, to the paying client, because payment on its own without that contract specifying the transfer of rights doesn't mean that they then fully own the intellectual property, in that work. And one of the interesting things that we have also experienced is that most of these agencies or these branding and marketing professionals end up getting into trouble, and the primary cause of litigation against advertising agents mostly comes from the unauthorized use of intellectual property of others. So you find that on the internet, a lot of information is readily available, video clips, images, logos, and all that, you name it, but it's available on internet. And some professionals have a tendency of just plucking that out of the internet and using it without doing a due diligence, without checking the ownership rights. Now, most of this content, images, and video, which is regarded as free, right? It's free to a certain extent, especially for non-commercial use. But when we are using that content for commercial use, creating commercial content for clients that is paid for, yeah, you have a problem there, because that's a different scenario altogether. And you always need to make sure that you check and verify that the information you are using is readily available, it's free, and there are no claims of intellectual property infringement that will end up following you together with the client that you are doing work for. So when it comes to that kind of ownership, one always have to make sure that they check the ownership of that content. And we have adverts and promotions that are also running on radio, on TV, and advertising and marketing agencies. They're always doing that and creating that content for clients. But sometimes you find that published music, which falls under copyright, that is used in adverts, it has to be, consented to by the owner of that music. But of course, the music aspect makes it a bit complicated, but it's always important to make sure that as a professional or as a company, you have done your due diligence in terms of the content that you are using. You might need to engage the publisher of that music. You might need to engage the composer in terms of the artists who have performed those songs. Sometimes the rights would have been transferred by the artist to the recording companies. You also need to make sure that the music that you are using, you have the rights and you are free to use that without a claiming of infringement. So in this case, you also need to really do your due diligence in terms of what you are using, and if it's free, and you are allowed to use that. I've got an interesting story in terms of trademark protection. I also believe it's very important because branding and marketing agents, they are always creating logos for clients. And when that happens, you don't normally discuss trademark registration, which I do believe is a very important aspect of an extension, probably, or an extension to the services that you offer to your clients, where you also then end up including a trademark registration, which we can then do on your behalf. Now, if you have created that trademark, it needs to be registered, and the rights, the copyright, again, it still remains with you until it's transferred to the paying client through that contract that I've mentioned before. So the most important part is that always look into having contracts with your clients, and those contracts clearly indicate whether or not there will be transfer of rights, especially for those branding agencies who would create content and information and they want to use it for other campaigns or for other clients. So if your contract doesn't specify that, you might end up in a fight with a client where they feel that you created content for them, they paid you, but again, you are using that content to do campaigns for other clients. So again, those aspects should be addressed by the contract. Whether or not you are fully transferring the rights, you're not going to use that content again. So branding agents, you also need to look into that, where if you want then to continue using the content that you have created for another client, are you free to do that? Did you do a contract that addresses that? And of course, the other option will be assigning those rights to a client for a specific period, where you're saying, I mean, you've paid, we've created this, we're assigning the intellectual property rights to you for this period. Why? Because you also need to use the same content for probably different campaigns. So that way you can then address that and make sure that you are clear of claims that can come even from the client. I mentioned a story just before, an interesting one. Apple was really in trouble at one point, and they had to pay around $60 million to make sure that they are able to use the iPad trademark in China, because that iPad trademark was registered by another company, and they wanted to venture into the Chinese market and to sell the iPad, and they couldn't do that because the trademark was registered. So as a branding agent or an advertising agent, besides those trademarks or the logos that you create for your clients, you do have your own logos, and those should also be registered as trademarks to make sure that no one copies them, and or no one uses something that is similar or closely confusingly similar to your trademark, because at the end of the day, that's how you then lose clients, because they are confused. But with the registered trademark, the story is different. You can actually seek recourse, legal recourse. You can actually sue on the basis of a registered trademark. So it's something that is really important for you guys to look into, and we'll be happy to help you on that one. So I'll also talk about the strategies that you can use as a branding agent or a marketing agent around intellectual property, where you can then look into offering trademark registration as an extension of your services, besides creating the brand. Of course, I understand the brand name and the trademark, they've always been used interchangeably, but the branding name is a marketing concept. The trademark is the legal concept around that brand name. So you can offer that as an extension of your services, where you actually include trademark registration in what you create for your clients. And again, from a company point of view, you also need to make sure that you register your own trademarks and trade names to make sure that you are not copied. Another strategic approach is to then combine the trade name, the trademark, and the domain name. It's also very beneficial and strategic to then have a domain name that also matches your trademark. And of course, using that trademark consistently and properly. Then most importantly, when we talk about ownership of intellectual property, I talked about company ownership, employee ownership, and client ownership. So in terms of ownership, yes, we do understand that the law is quite clear that intellectual property created during the course of the employment is owned by the employer. But it's always prudent and important to make sure that as a company, you have a policy in place, and that policy also cascades down to the employment contracts, and your employment contracts address the issue of ownership of intellectual property, and the employees are aware that this content we are creating, this intellectual property we are creating, is owned by the company, and they won't have claims over it. Because sometimes, I mean, it might sound funny, but in some cases, employees create this, be it content or work that they do, and yes, the intellectual property rights are assumed to be owned by the company. And when the company makes money out of that, whether someone is still there or they've left the company, they feel that they could also have made money out of that because they created that. So when you do have proper contracts in place, that should be easier to handle. And of course, employees won't then end up bringing up claims against the company out of the intellectual property that they've created. So I think those are the key issues that we need to address in the marketing and the branding space. But of course, like I said, feel free to ask questions, to comment, so that those questions can be answered. I will be addressing them as they come. So yeah, feel free. I mean, this is a discussion after all. Let's try to make it as interactive as possible. Thank you so much.